Welcome, everyone. My name is Luke Hayes. I'm the Director of Mobilization here at Understood. And today we have a great webinar topic that we're really excited about, and we know a lot of parents ask questions about this. Your child's rights in the IEP process. And joining us today to give her just her wealth of experience and knowledge about the subject is our very own Lindsay Jones. She is our Vice President and Chief Policy and Advocacy Officer with the National Center for Learning Disabilities. So Lindsay, welcome to the webinar. We're excited to get started.
Yeah, thanks so much for having me. It's a great topic.
All right. So first off, we're going to start off. What is the process? How does my child get an IEP? How does one initiate this process?
Yeah. So the process to initiate an IEP, it can come from either a parent or an educator in the building. And federal law and state law both provide some specific guidelines. So I want to point out that every state is a little bit different when it comes to some of the procedures we'll be talking about today. So it's important to understand that and be sure to check with your state for how they may change. But in general, most of it will be governed by federal law and guidelines and procedures put in place. So how do you get an IEP? If you're concerned that your student, that your child is struggling in school, the best first step is to speak with their teacher. Try to understand a little bit about whether the teacher is seeing the same struggles that you are, what he or she thinks is a good next step. The federal law provides every parent the right to ask for an evaluation of their student. So the first step is to speak with your teacher, but there is the need probably in working with them or at some point, if they agree with you and if you continue to think this, they don't have to agree with you, but to put your request for an evaluation in writing and submit that to the principal of the school. That will start your process for getting the on board with the district and what will then become a decision that the parents and the district make about whether the student qualifies for services under the IDEA.
All right. So you mentioned evaluation. So let's say, as a parent, I took the initiative and I got a private diagnosis or a private valuation separate from the school. It says my daughter has dyslexia. If I bring that to the IEP team, do they have to follow that diagnosis, or does there have to be one that's officially conducted by the school?
So that's a great question. The school they're not required to accept the outside evaluation, but they are required to consider it, and they should be considering it very thoughtfully. So the IEP process is set up in that it's meant to create a team of individuals who have knowledge and understanding of the child, and then have other various areas of expertise. So federal law actually sets forth who has to attend the meeting, and every state may differ a little bit in that process, but it still has to be a general education teacher with knowledge of the child, a special education teacher with knowledge of the child or with expertise that they can add if the child has never received special education services, and someone who can make a decision on behalf of the district. That's usually the principal. It could also be the special education director, and someone who can interpret evaluation results. So when you're asking about when a parent brings a private evaluation to a meeting, the school district typically includes a school psychologist, and that is a school employee, but it's a person with training to be able to really read the assessment data and provide that type of understanding and expertise for the team. So if a parent has gotten the evaluation from an outside evaluator, someone not associated with the school, and hasn't initiated an IEP, individual education plan process with the school, the best first step again is to go to the teacher, let the teacher know that you'd like to request, basically an evaluation from the district as to whether your child is eligible for services under IDEA. Then they should set a meeting of a team that I just described to discuss how to begin this process. And it's appropriate at that meeting to share the private evaluation and say, in addition to the experience I have understanding whether my child's struggling, here is an evaluation that we received and it provides all of this information. The other thing that's important, I think, for parents, and Understood has some great tools about this, is you're going to want to document for yourself the places you see your student struggling, so that you can provide that information to the team as here are the objective times I've noticed this struggling is occurring. That's just going to help that conversation move forward.
Great. Well, thank you for that. I want to stay on this for one more question. Just this is something we've heard a lot from parents, is that they know their child has dyslexia or ADHD, but when they're in the IEP meeting, there's the term like, my child, my daughter has reading issues or whatever that might be. Is there a reason they're not saying the word dyslexia, or should they say it, or how does that work?
Yeah, this is such a common question. And we've worked so hard here at NCLD with the federal government, with state governments, and with our educator associations to try to break down this myth. Let me be absolutely clear. The statute, the Individuals with Disabilities in Education Act, IDEA, which we're referring to here, which governs this process of special education, at least this portion of it, clearly includes the term dyslexia. It's in the statute. There's nothing that should prohibit a school district from using that term. Now, there are a lot of other terms in the statute, and school districts should be able to use those terms as well. What a parent really wants is the most precise definition and statement of their child's needs, because the IEP should be built around their needs and their strengths. So just to be clear, there's no reason a school district should ever refuse to put the term dyslexia in an IEP. NCLD, along with lots of our allies in the disability community and the education community, worked with the U.S. Department of Education, and they released a piece of guidance on this in 2015. Michael, at the time, we have a great interview actually on Understood with Michael Uden, who was the Assistant Secretary for the Office of Special Education and Rehabilitation Services there. That piece of guidance encourages districts to be using language and terms that their parents use as well, and clearly again states the terms dyslexia, dyscalculia, dysgraphia, these are in the statute. There's a piece of guidance telling districts and states, use this term, don't be afraid of it. In addition, I just want to say we've got a great, because this has been such a persistent problem, we came together with some other organizations, the National Association of School Psychologists, the Council for Exceptional Children, the National Association of State Directors of Special Education. We created a document, we call it a conversation starter document, and you will see, I think we can link to it here, but you will see the logos of all of those organizations at the bottom of that document, because all of them are saying, here are 5 different ways you can talk about how to talk about dyslexia in an IEP, or dyscalculia, or any of those more precise terms. But the language in the statute does drive schools and districts to talk about the category of learning disabilities in a broader way. And that's because many, many of our children have comorbid issues with attention, with dyslexia, with reading issues. Some children don't have decoding issues. They have comprehension issues with reading. So we don't want school districts to in any way create a checkbox and say, oh, dyslexia, you get X, and everyone who has dyslexia gets X, because that really undermines the purpose and goal of the statute, which is to focus on the individual child and create a document that is tailored to their strengths and their needs.
Great, thank you. We have a question, a follow-up to this from one of our users, Zephyr. Zephyr wants to know, where does response intervention fit within the IEP process?
This is such a good question. In every couple years, Congress reauthorizes IDEA. And in the last reauthorization, Congress included a way to identify a specific learning disability called response to intervention. Response to intervention is a system-wide process. It's a process that a school or a district puts in place, and it's really to do 2 things. The first thing is to help them look at all students and screen them and determine, are there issues with reading? Are there students that are demonstrating risk for potential academic issues with reading or math. It's typically in elementary school environments. This is for all students, and it has no relation necessarily to whether or not you're identified for a specific learning disability. So districts will use the RTI process in that way. It can also be called multi-tiered systems of support. But in the 2004 reauthorization of IDEA, Congress specifically said states can choose to use response to intervention as a process to determine whether a student has a learning disability. So when you ask for an evaluation, or if your teacher or district determines that you have signs that you're struggling and they want to evaluate you, think your child needs an evaluation, they may also put into place response to intervention. This will be, it's governed by state. The way they'll do it is set forth in state procedures, regulations, and laws. But it's basically the same kind of tiered process. It's where they're going to try some targeted interventions with your student. They're going to monitor how your student responds to those interventions. They may try a couple tiers of those. And at the end of that, if your child is not responsive to the interventions that they're applying, then they will make a determination that your child has a specific learning disability. But the process itself is based in evidence, and it has, when it's implemented well, which unfortunately is challenging, and I'm not sure it is implemented well in all places, but when it's implemented well, it is, most experts agree, it's the best way to make a really great decision about whether your child has a specific learning disability. Districts, the final thing I'll say about this is districts can add some cognitive testing to that if they want. It's a little bit different in many places, but the general gist of the process is they're looking at whether your child's responding to really targeted interventions and what that tells them about their needs.
Great. Thank you, Lindsay. We have a question that's come up a little bit on the chat, one from M. Clark. What is the role or difference between public and private schools with regards to an IEP? You mentioned districts and them having to implement it. Does that apply to private schools as well as public schools, or is there a difference?
So there is a difference. IDEA does not apply to private schools. So private schools don't have to give your child an IEP. You don't have a right to attend meetings. You don't have rights to challenge the school or sue the school about decisions that they're making. You have no rights in a private school to any of those services. It's all just up to that school. So in the public school, you have all those rights. You can, as you can read through them on Understood, you have a lot of rights around decision making. Probably the most important right is you have a right to be a part of the decision, and you have the right to disagree in a public school. You do not have that in a private school. And I want to be clear here also, in a public school, when I use the term public school, I mean charter schools as well. People often have a misconception that charter schools are private schools or they're not subject to our federal laws of IDEA. That's wrong. Charter schools must enforce IDEA just as traditional public schools do. There is one more complication here in terms of private schools. Private schools don't have to apply, they don't follow the federal laws of the IDEA. But IDEA has a provision, it's called child find, and it puts the burden on the school to find the students who need special education services. And in one component of IDEA, public schools do have to reach out to any private school that is located within their geographic boundaries, their school district, and seek, kind of work with the school to find, are there children in the private school who need special education services? They have that child find responsibility with those schools in their district. And then it's on the parent. The parent can choose to move their child to a public school to receive the services, or the public school does have to provide something called this private proportionate share. It's a very small amount of money, and it is entirely within the discretion of the public school district as to what they provide. So some school districts will say provide speech services to children in private schools, but that's it. You don't get any other rights to IDEA if you're in a private school.
All right.
So I feel like I'm in a, I don't know, in a law class or something. Or there's going to be a light on me. Like, it's so very funny.
No, thank you for their clarification. And again, these are questions that we hear both online and on the ground. Continue on this distinction of what rights you have and what the districts are required to provide. For tutoring or summer school, is that something that a school is needs to necessarily provide for a child with an IEP, or?
Yeah. So any services that are offered in the summer by the school district go under the legal name extended school year. And what is supposed to be happening is an IEP team should be meeting once a year. And as a part of that evaluation, they should be determining whether the student will lose lots of what they've gained over the summer, such that they need extended school year services. So the IEP team should be conducting basically an extended school years type of evaluation to see if the child qualifies for those programs. It's up to so it's very individualized. It's totally based on the needs of the student.
Okay. Now, one thing we often encounter is a parent will say the school says your child isn't eligible for an IEP. What are the next steps to get a child that help or any help through the school?
Sure. So the IEP team may find that the child does not qualify for services under IDEA. The parent, as a member of that team, and I think Understood has an article kind of about what this is, but the parent has the ability to disagree with that determination. And there are several steps the parent can take. They should put in writing that they disagree with the determination. The district should provide them some information about what the process is to actually disagree. And typically that involves drafting some documents about why you disagree and either going to a resolution session, a mediation, but it's all falling under your procedural safeguards. Those are your procedural rights. So it's very important that if you disagree with your IEP team, you ask for and receive what is called your procedural safeguard notice. And you need to follow the rules that are set forth within that to challenge the decision of the IEP team.
All right, so just to clarify, if you think your child's IEP isn't working or you want to adjust something, do you need the procedural process you just referred to, or is that something separate?
That's actually a little separate.
Okay.
So if you already have an IEP and you want to make some changes to it or propose some changes or talk about why your child's not progressing or making progress, the first thing to do is call a meeting of that IEP team. The district has to have the meeting and present your concerns to the IEP team. And the IEP team within that process can determine how to respond to those concerns. If you disagree with the decision that the district makes about, let's say, the placement of your student, then you do use the same process that I described earlier about when you have a child that hasn't been found eligible. It's the same procedural safeguards and the same process. The difference is that when you already have an IEP, the first step is to meet with the school and talk about why you think the changes are needed and get their opinion and see if they'll agree to some of those changes or if they have ideas for how to make the education work better.
One thing that's come up and actually Understood, I think in collaboration with your team, released a toolkit recently around Andrew F. And if you could just talk a little bit about that case, and kind of the implications, or what it had to do with the IEP process.
Sure. So, I mean, Andrew F. Was a decision of the United States Supreme Court. It's our most recent decision from that court on what a free, appropriate public education is. So certain states in the United States were following a standard that was referred to by the courts as de minimis, which really sort of means trivial. And what the standard said was that if a child with an IEP, if a child receiving services under special education, an IDEA, receives de minimis or trivial benefit from those services, that's enough. The court and a family in Colorado said no, that's not enough. Trivial. That seems, what's the purpose of an education if all it is to give you any sort of benefit, any trivial little amount of benefit? Certainly, NCLD's position is that all of our children should be making great gains, but should be making progress, steady progress, and should be achieving on grade level standards. And we think that IEPs should put forward a plan that tells a parent, how is my child going to get to grade level this year? What are the things you're doing to put in place to make that happen? Andrew F. was where the Supreme Court ruled eliminating the trivial standard and agreeing in some ways with us and saying nobody goes to school to make just minimal or trivial progress. Andrew F. said a free, appropriate public education must be reasonably calculated and in light of the circumstances of the student, for that student to make appropriate progress. We'll now spend some time figuring out what that means, but it's more than just trivial. It has to be meaningful progress, and it should be progress that is getting a student to a place where they're graduating from high school. So Andrew F. and our toolkit, I think, is a terrific tool for parents. It really says to parents, okay, here's this legal case. It feels very distant from my IEP meeting. How do I make my IEP meeting better so that I can see the progress that my student needs to be making? So that toolkit is a set of questions and talking points for parents to use in the meeting to kind of bring Andrew to life in that meeting. But the one goal is, how will you show me in this IEP that my child's going to get the services they need to reach grade level achievement?
Thank you. We have a technical question from one of our users, Stone. Is there a legal time frame for schools to implement the services once an IEP is signed by a parent?
Yes, there is a time frame. Once an IEP is signed by a parent, the district has a reasonable amount of time to put those into place, but I can't imagine that would be any more than a week. It would have to be, it might be depending on, it's one thing where you'd have to look at kind of what those services are. But the IEP should go into effect immediately once everyone has signed. So there should not be any delay other than a logistical delay. Let's say, you could think of a situation where maybe a day or two you would have to if your child was moving to a different school or a different placement. Certainly there's a reasonable logistical delay, but there should be no undue delay once the IEP is in place.
Okay, great. Thank you. And a clarification, I know I asked this before, the procedural process, what was the name of that specific term for the IEP?
Oh, it's called, the way that it's listed is a procedural safeguards notice.
Procedural safeguards.
So everyone should get those. You should get one annually, but you should always have it. It'll differ by state.
Great. Thank you, Lindsay. And one thing that we get a bit is a kind of the distinction between an IEP and a 504, and kind of some schools might suggest a 504 instead of an IEP, and what that means, and kind of how that affects your child with a learning intention issue. Sure.
So a 504, that number refers to another federal law that's called the Rehabilitation Act, and it's the section of the law, Section 504. And so Section 504 was actually passed before IDEA, and it is, both IDEA and Section 504 are civil rights laws, but IDEA comes with funding and has many more rights for parents under it. So Section 504 is a law that is also a law that you may have a student who qualifies for services, and as a person with a disability under Section 504, a lot of students with ADHD have Section 504 plans, and they do have procedural safeguards and due process rights, but there is no funding that goes along with Section 504, and it is not providing specialized instruction and services as its main goal. Understood has a terrific chart that can really clearly kind of outline for you what's required by 504 what's required by IDEA, and you can compare them. But in general, specialized instruction and the services along with it are typically provided under IDEA. Section 504 might be used for a student with a medical disability as well, or diabetes, or those types, or an allergy to latex or something, in addition to some of the areas of learning. And it will provide just accommodations to sort of equalize the environment. It will not typically provide specialized instruction and support. That's more under IDEA.
Lastly, this will be our last question for the day. Is there any advice as far as for parents when they're in the meeting with the IEP team, as far as certain phrases or acronyms that they should be aware of, just to know as that conversation's taking place? Sometimes acronyms or terms get thrown out. Are there some key phrases or terms that are really helpful for this process?
Yeah, my advice to parents: look, when you go into an IEP meeting or a Section 504 meeting, it is a really challenging circumstance. You are sitting at a table full of educators who are busy and running around, and you're talking about the most precious thing in your life. And I think you need to feel comfortable to ask and to interrupt, because you are not meant to be an education professional or a legal professional. You need to, they are very likely to use acronyms. And honestly, for any parent who has a kid in one of these circumstances, in a year or two after you begin this, you will be using those acronyms all the time as well. But in the beginning, my advice is Understood has glossaries on it of these terms. Understood has some great information about them. I was an attorney for 10 years in Arizona representing public school districts and parents in these meetings. And when I first walked into those meetings and I heard, FBA and BIP and FAPE, and I didn't know what those words were. I think as a parent, you just have to be confident and calm and nice and ask. Slow them down and ask, because nobody will ever know all of these things. And I just think you shouldn't feel intimidated by that. You should try to just make sure you're understanding them. But the reality is you're probably going to have to look at sites like Understood to understand what's ESY. We talked about extended school year. Understood has some great information that's easy about what that is, but you should also feel very comfortable to ask kind of, how are you going to measure the goals here? Who is going to have a copy of the IEP? How will I get progress reports about my child's progress? Who will, what is FAPE? How are you meeting that requirement? What is ESY? Are you incorporating behavior into this? Have you evaluated that? An assistive technology evaluation. Have you conducted that? How would that happen? You're going to have to ask a lot of questions in these meetings. I think it's perfectly appropriate to record the meetings. I think that might make schools uncomfortable, but for parents who are taking in a ton of information, it can be really useful to record the meeting so that you can listen again, just as it's useful for our children to record lectures and be able to go back and understand them. I think you need to know who's your point of contact. There's a lot of different parts about this process that can be overwhelming and overly legalistic. The most important thing is to know that you don't have to know everything. You're not going to know everything. No one should expect you to know everything. And really, I would just encourage them to ask.
Sage final words. Thank you so much for joining us today. To Lindsay and to the online audience, we look forward to our next expert chat. And I hope you all have a great day and a great Memorial Day weekend. Bye from Understood.